Since you may not have been here when we started, I'll remind Appellants Counsel, if you like to reserve time for rebuttal, let me know, please.
Yes, Judge. May I please reserve 5 minutes?
Certainly. We're ready, Counsel, if you are.
Thank you. Good morning, and may it please the Court. My name is Adam Knight, and I represent the appellant, Mr. Roberto Andrade-Gonzalez, in this matter. The trial court incorrectly entered final judgment of foreclosure for 3 reasons. First, the appellee failed to prove its standing to foreclose at the time of filing, and Ocwen specifically failed to prove its authority to act as the loan servicer. The second reason is that the appellee failed to prove compliance with conditions precedent to acceleration and foreclosure. The third failure of proof is on damages. They failed to prove the amounts due and owing with admissible evidence.
Can I ask you a question? Has the debt been discharged in bankruptcy at this point?
Yes, Judge, it is my understanding.
This debt was it a deficiency judgment that was listed as a debt in the bankruptcy proceeding?
My understanding, and the record does not go into this other than, I believe, Exhibit 5 was the bankruptcy petition. The discharge was never tendered as an exhibit. My understanding is that, yes, there was an actual discharge entered in 2008.
Okay. And so there was an admission on the part of your client that he stopped paying.
As to the default, yes, I believe that there is an admission.
So he admitted that he wasn't paying, then filed for bankruptcy, listed it as a debt which has been discharged. What is it that you're after?
Well, to the extent that the court is concerned about whether or not the bankruptcy discharge has any impact on the ability to defend against the mortgage foreclosure, the Korea case, I think, speaks to that. And in Korea, the borrower had similarly discharged the indebtedness in the bankruptcy, and this court, in considering an appeal of a trial decision on a foreclosure case, reversed with instructions for involuntary dismissal. So our position is that the bankruptcy has no impact on these proceedings or the ability to challenge the foreclosure, other than the fact that a deficiency judgment would be unavailable.
I'm just puzzled because if your client is not subject to any deficiency and the property's been sold, are we just here on an academic exercise? I mean, is he trying to get the property back, or because foreclosure is an equitable proceeding, correct?
Yes, Judge.
So if he stopped paying, he listed the debt, it's been discharged, the property's sold. What do you want? What are you asking for?
What we're asking for is that the judgment be reversed, and that could potentially include reversing the sale. The problem with going down that path concerns due process. Mr. Andrade has a due process right to defend against the foreclosure, irrespective of whether or not he listed it in a bankruptcy. Ocwen, in this case, still had the burden of proving that it was entitled to foreclose.
Does the record tell us if in the bankruptcy proceedings he listed anyone else who would possibly be the holder of that note?
To my knowledge, no. And the bankruptcy petition was admitted. No, I do not know if that was in full.
It was or was not? I'm sorry.
The answer to your question is I do not believe that he admitted that he said anyone else was the owner and holder. But I still think that when we look at the issues, they had to prove standing when they went to trial. They didn't get summary judgment, so at trial the burden is on them to prove standing. One of the affirmative defenses was that the plaintiff lacked standing to foreclose, and they didn't do it for 2 reasons. First of all, there's absolutely no evidence presented at the trial court level that Taylor, Bean, and Whitaker was the owner and holder at the time of filing. Now, when they initiated their complaint in 2008, they attached a copy of a note, but they also had a lost note count. So what they were essentially saying is, we're not the holder, we're entitled to enforce a lost note, meaning they needed to prove up the elements of that they
didn't they subsequently file the original note and mortgage in 2009?
That's correct, Judge, but the filing of the note and mortgage in 2009 speaks nothing at all to the issue of whether or not they were the holder at the time of filing.
In May of 2009, excuse me, Judge? Because it was in blank?
It was endorsed in blank when filed in 2009, but there was no accompanying affidavit, and there was no testimony at trial to the extent that they were saying, we held the note prior to the filing. The only date on which this court could conclude that the Taylor, Bean, and Whitaker held the note and mortgage was on I believe it was May 19th of 2009.
Is there any evidence of record that they did not? Of record?
Yes, yes there is. There is trial testimony that Freddie Mac in this case held the note and mortgage as early as December 27th of '07.
Who offered that testimony?
That was offered by the defendant.
Wasn't there an objection? It was sustained?
I do not believe there was an objection to that piece of material, and I'd be happy to check
No,
the
that's
record.
okay. And at one point, there was a mention that the appellant was tempted to put in evidence that on the computer screen.
That is correct, Judge.
That was sustained. So this is a different testimony.
This is
Okay,
different
thank
testimony.
you.
That was a proper, what you're speaking to with the computer, that was intended to be used with the bank representative, Ms. Gina Johnson. Mr. Andrade separately testified under direct examination that the Freddie Mac owned and held the note on December 27th of '07, and there was no objection to that specific piece of testimony. And getting past
But
whether...
see, then what we're really, most of these cases come to us in a summary judgment
Correct.
context, but here, apparently I have conflicting evidence.
That would be a piece of conflicting evidence,
Which
but
the judge resolved against your client pursuant to the final judgment in the bench trial.
even to the extent that we could say there was conflicting evidence on the date at which Freddie Mac owned the loan, the question is this. Is there any testimony in the record or any document in the record proving that Taylor, Bean, and Whitaker had the note and mortgage at the time of filing the complaint? And the answer to that question is absolutely not.
Of course, as Judge Altenburn said in a recent concurring opinion, that may not be the best result. At the end of the day, the person who held the note held the note.
And I am aware, I was before this court a couple weeks ago, and I am aware of the decision in the Fox case where this court certified the question on standing to the Supreme Court. My position is this. The state of the law as it exists right now is you need to prove standing at the time of filing. This court and every court in Florida has been extremely consistent on that, and the Supreme Court has not ruled. So in this case, we have the law as it is, and the law is you need to prove standing at the time of filing, and that simply wasn't done here. And even if we get past that point, the trial testimony is unequivocal that Ocwen was not the owner and holder of the note when it went to trial last year. Ocwen specifically testified, or the witness testified, that they were the servicer for Freddie Mac. Now, that's problematic in and of itself because they did not tender any evidence establishing their authority to pursue the foreclosure action. And courts have addressed this several times in the past. The Elston-Leedsdale case specifically said, Rule 1.210 may permit you to bring and maintain a cause of action, but that does not obviate the need for proof that you have authority to act. And in the other two cases...
Those cases arise where someone is the agent for one of these trust situations that hold these securitized notes.
Elston-Leedsdale was.
Elston-Leedsdale involved a
securitization.
Yes, Elston-Leedsdale did involve a securitized loan. Our position is this is no different. In that case, we have someone saying, I'm the servicer acting on behalf of XYZ Securitized Trust. In this case, it's the same thing. Ocwen is saying, I'm the servicer, only they're acting on behalf of Freddie Mac rather than XYZ Securitized Trust. The result is the same. You have a person or entity claiming to act on behalf of another, and you have a trial transcript without any evidence of authority to act. That is problematic. The courts have been consistent in saying that, yes, you may act, but only if you present some evidence of authority or ratification. The Kamar case, cited in our brief, as well as the Wega versus Davidson case, both cited in our brief, the courts in those two decisions allowed the plaintiff to proceed, but only because there were specific affidavits on file authorizing that party to act. In other words, they had the ratification necessary to proceed. Here it's not the same thing. This is exactly like Elston. All they're relying upon is their own allegations and their own, in this case, not even their own affidavits, to support the claim that they have authority. They needed the service.
You can't establish agency. The agent can't establish its own agency. It needs some action from the principal.
That is our position, Judge, and the cases bear that out. And in this case, she specifically admits, and it's on page 59 of the transcript, that even if the court has sustained my objection on these hearsay grounds, they did not have the servicing agreement in court that afternoon in order to present that as admissible evidence of their authority to act. And for that reason, it's our position that they didn't prove the authority as they needed to under the state of the law as it exists, and because of that, an order of involuntary dismissal would have and should have been entered. And that's what we're seeking from this court, is a reversal with instructions to enter that order of involuntary dismissal. And the second failure that they have is regarding the conditions precedent. Now, case after case in Florida, again, has said paragraph 22 is a mandatory provision that you must comply with prior to accelerating the debt and foreclosing on the note and mortgage. Excuse me. So in order at trial to prove that they did so, they need to do it with admissible evidence. Here, what they submitted was a letter not from Ocwen, who is the only entity that testified at trial, but from Taylor, Bean, and Whitaker. There was no testimony from the witness establishing that they did any effort whatsoever to verify that particular document. And in fact, the witness was unequivocal that she has, quote unquote, no personal knowledge of Taylor, Bean, and Whitaker's business practices, and she was never employed there. And that's on page 58 of the transcript.
Can I take you off track for a moment? I always have difficulty trying to figure out how this is going to play out. So if we reverse, your client's not subject to a deficiency judgment, so he doesn't have to worry about a monetary judgment. He gets the property back, and he's going to have to make some payments going forward. How does this happen? How is this going to play out?
Our position moving forward is this. If the court reverses and remands with instructions to enter an order of involuntary dismissal, that foreclosure action is essentially done. And the plaintiff can choose whether or not to refile in the future at a time of its convenience. So in our position is they essentially just have to start over again to the extent that they're allowed to.
Which would also entail evicting the subsequent purchaser at the foreclosure sale.
I apologize, Judge, I was not able to hear you.
My understanding is that the briefing suggests that this property was sold, so there's an occupant or an owner following the foreclosure sale, so there would be some sort of, I'm going to use the word eviction, that may not be the correct dirt law term to use, but that person as well.
Yes, Judge. That is cited, I believe, in our brief, in our statement of facts, and that is my understanding. I don't have independent confirmation of that. I apologize.
That's
but,
okay. It'd be outside the record. I just noticed it in the briefing.
To the extent that person would be considered innocent, we had filed our notice of appeal of this decision prior to the sale. So they were on notice that there was continuing litigation and that this could ultimately result in a reversal. But getting back to where I was, on paragraph 22, they just simply didn't meet the hearsay requirements. And the Glarum case is somewhat instructive on this, and it's also cited in our brief. And in that case, the court said very specifically that the testimony of a business records custodian was inadmissible because they were relying on records from a prior servicer, and they had no knowledge as to how those records were created, produced, maintained, etc. Exact same testimony here, only more clear. I wasn't employed by Taylor, Bean, and Whitaker, and I have absolutely no personal knowledge of their business practices. That in and of itself creates the Glarum issue and means that they didn't establish the hearsay exception for the letter. But even going further, if we get past that, they still need to allege each of the 4 elements of the business record exception to the hearsay rule, which they don't do. The 2 that are specifically missing are there's no testimony that the letter was created by or from information transmitted by someone with knowledge, and there's no testimony on the record that that letter was created at or near the time of the event. The only arguable testimony presented along the lines of the exception itself was relative to whether or not it was made in the ordinary course of business and whether or not it was a practice to make that. But then we get back to she can't testify as to what Taylor, Bean, and Whitaker's practices were. So we have that problem as well. The last issue on paragraph 22 is where it was sent. Mr. Andrade's testimony was pretty clear. He had designated a notice address with the prior servicer, Taylor, Bean, and Whitaker. That notice address was at 2028 Shadow Pine Drive in Brandon, Florida. Despite the fact that he had provided them with an alternate address for notice, they simply, according to their practices, sent this directly to the property. And he stated that the reason why he gave them an alternate address was because he was in and out of the country, I guess dealing with personal or family issues. In any event, if you send the letter to the wrong address when you had notice to send it somewhere where it might actually be received, our position is that you haven't complied with the conditions precedent to foreclosure. And that's argued a little more fully in the brief, but I think it's a relatively simplistic point that if you send the letter to the wrong address, that's not notice. Last but not least, we have an issue with the amounts due and owing. And at trial, I know the record may be a little unclear on exactly what was admitted. I think the entirety of Exhibit 3 was sent up to the appellate court. The only 3 pages that the court let in were the first 3. And the problem with those 3 pages are that they were prior servicer records, and there's not enough testimony in the record that they verified and checked the accuracy of those prior to using them. And then the second problem is the transcript is, again, void of any evidence regarding testimony as to the 4 specific requirements of the hearsay exception. And you know, what we have is essentially, if you read the transcript, a lot of documents and information that was admitted over objection, specifically hearsay objections. And again, I come back to, just to briefly touch on the result, particularly regarding the standing argument. We have a situation where there is an absolute failure of proof. I know that the court is considering sending a case up, but here we have a situation where Taylor, Bean, and Whitaker, or Ocwen, presented no evidence that Taylor, Bean, and Whitaker was the owner and holder of the note and mortgage at the time of filing, presented no evidence that Taylor, Bean, and Whitaker was a servicing agent authorized to bring a foreclosure at the time of filing, presented no evidence that Taylor, Bean, and Whitaker was trying to enforce a lost note and was entitled to do it that way. None. Rather, they proceeded on a holdership theory, but as I explained earlier, the only date that we know Taylor, Bean, and Whitaker held the note and mortgage was in May of 2009, 11 months after the foreclosure was filed. And because of that failure of proof, this case becomes more like the Korea case, where this court said, look, you don't prove your case, we reverse with instructions to dismiss, not to have a new trial. And the reason for that is because we're not engaging in trying to extend or protract litigation. Litigation should be efficient and effective. And the cases cited in there are the Carlo versus Nationwide case. And again, that was where the attorney, showed up and tried to use court documents in order to prove what the point he was trying to prove in an evidentiary hearing. And this court, or that court, said, no, you can't do that. You needed to present admissible evidence. So our position is this court should reverse for 3 reasons: lack of standing, lack of evidence on paragraph 22 compliance, and failure to prove the amounts due and owing with admissible evidence. Thank you.
Thank you.
May it please the court. My name is Michael Larson on behalf of Ocwen Loan Servicing. And at first, I'd like to address some of the points raised by opposing counsel. Taylor Bean had standing at commencement of this action. It filed a complaint in which it alleged that it held the note. It attached a copy of the original note to the complaint. The original note was made out in favor of Taylor Bean and Whitaker, and it was also endorsed in blank. So Taylor Bean had 2 grounds that support its standing at commencement of the action. And the case law supports that where a complaint attaches a copy of the note, that is sufficient to support standing at the commencement of an action. So Taylor Bean had standing when this action began. And further, Ocwen had standing to enforce the note after its substitution. Taylor Bean filed a motion to substitute in 2009. So the trial court decided this issue of substitution 4 years ago.
So you would view that as an expression by the principal that allows the agent to proceed?
Well, we view this as Taylor Bean. Yes, in the motion, it essentially asserted that the loan had been transferred to Taylor Bean for servicing and that Taylor Bean could enforce the note's terms. The trial court found Taylor Bean...
That's an assertion by Taylor Bean and Whitaker.
Yes, an assertion by Taylor Bean and Whitaker. And even independent of whether an agent can enforce an action on behalf of a principal, Ocwen is the servicer in this case. Ocwen has its own interest in this litigation. Ocwen collected payments, Ocwen manages default issues, Ocwen interfaces with the borrower, and we cite several cases in our brief. One case is the Azizi case, which cites a case from the 11th Circuit, Greer versus Odell. In that case, the 11th Circuit found that a loan servicer is a real party in interest in proceedings involving loans in which it services. So the trial court here found that Ocwen is a real party in interest. Ocwen, as a loan servicer, can foreclose upon the note. As an addition...
But absent the motion to substitute filed by Taylor Bean Whitaker, in order for Ocwen to assert its position as a party in interest, wouldn't I need some evidence? I would need the servicing agreement at a minimum, would I not?
Well, here
That
you're-
shows that Ocwen is indeed authorized to do all these things on behalf of the note owner.
And our position is evidence was provided. That evidence was provided through the testimony of Ms. Gina Johnson, who is an Ocwen senior loan analyst and had been since 2004. She testified based on her personal knowledge that Ocwen could enforce the note. The loan servicing agreement was not admitted into evidence, but her testimony serves to support Ocwen's status as a loan servicer entitled to enforce this note. So the
Any
evidence...
testimony rebutting that?
What's that?
Was there any testimony contrary to that to establish that Ocwen was not a loan servicer?
No, and in fact, Mr. Andrade-Gonzalez testified that he believed that he owed Ocwen money. He testified that he has only spoken with two entities regarding this note. The first is Taylor Bean and Whitaker. The second is Ocwen. Both of those entities were plaintiffs in this case. Ocwen is the current plaintiff. Taylor Bean was the plaintiff that originated this action. And Mr. Andrade admitted that the loan is in default. He admitted that money is owed, and he admitted that he believes he owes money to Ocwen. So if anything, his testimony supports Ocwen's status as a servicer entitled to foreclose this note.
Did he testify before or after the motion for judgment of involuntary dismissal?
I believe, Your Honor, he testified before, but I'm not
So
I'm
it
not
would have
certain.
been called by your client, then is what you're saying.
Yes. Further, I'd like to address opposing counsel's arguments regarding conditions precedent.
So there's nothing in the record disputing the right of Ocwen as a servicer?
No.
Nothing.
No, Your Honor, there is nothing in the record.
I'm not aware of any cases, perhaps your opponent will cite me something that requires that the agreement be put into evidence. If she's giving testimony that this is what she's doing and nobody contests it, do we need the document?
It is our position that we do not need the document, and I do not believe any cases were cited by opposing counsel that require the document itself be introduced into evidence.
You opposing counsel?
Document be the best evidence of whether or not there was a contract between the parties that delineates the duties between the parties?
We believe that, Your Honor, that her testimony is sufficient. I'm not sure whether it would be the best evidence, but it would be, we believe her testimony is sufficient evidence.
If she is testifying from what somebody else told her that they're their agents, that would make it hearsay. If she is publishing from the document, would that make that her testimony also hearsay if properly objected to?
Our position is no, Your Honor. Here, we cite a
witness
case.
not-
We cite. Oh, I'm sorry.
Go ahead.
We cite a case in our brief, In Re Sagamore Partners, that says review of business records is sufficient to form personal knowledge in order to testify. And here, Ms. Johnson reviewed the records. She could testify based upon those records. She had personal knowledge that an agreement existed, and she was able to assert that Ocwen is servicer for Freddie Mac and can foreclose upon this loan. So now I'd like to discuss the conditions precedent issue. All conditions precedent have been satisfied in this matter. Paragraph 22 of the mortgage requires that a default notice be sent. And here a default notice was sent. It was a letter dated February 4th, 2008. Taylor Bean and Whitaker sent this letter, and Mr. Andrade-Gonzalez disputes whether the letter was sent to the correct address. But paragraph 15 of the mortgage requires that in order to change a default notice address, Mr. Andrade-Gonzalez must give notice in writing. Here, there is no evidence that Mr. Andrade-Gonzalez gave notice in writing to Ocwen or to Taylor Bean and Whitaker regarding the default notice. And in fact, he testified that notice was only given orally. It was given over the phone. That is insufficient under the mortgage, which he executed, and therefore that the notice that was sent to the mortgage property address, and that is sufficient under paragraph 22 and paragraph 15 of the mortgage. Further, the loan payment history and the default letter, the trial court did not abuse its discretion in admitting the loan payment history or the default letter into evidence. This court in WAMCO discussed a similar issue. In WAMCO, the WAMCO Bank bought loans from Bank of America. Bank of America transferred transferred records to WAMCO. WAMCO verified those records for accuracy. Those records were admissible at trial. And here, the same thing happened. Taylor, Bean, and Whitaker transferred records to Ocwen. Ms. Gina Johnson testified in detail regarding the types of records received, the collateral files, the servicing files, the data files. She testified that it was a priority of Ocwen to verify those records for accuracy, and only after those records were verified for accuracy were they put into service in Ocwen, and Ocwen could rely upon those records. And she testified that these documents were verified, those records were relied upon by Ocwen, and the trial court did not abuse its discretion in admitting those documents into evidence at trial. If the court has no further questions, we respectfully request that this court affirm the final judgment of foreclosure because it is supported by competent, substantial evidence. Thank you.
Thank you.
I'd like to first come back to the standing argument. The position is, from Appellee's seemingly, that because the complaint attached a copy of a note that was unendorsed, that in and of itself is sufficient to prove standing. It may be sufficient to survive a motion to dismiss. It does not constitute proof at trial, and that's the distinction that makes a difference. On the ability of Ocwen to enforce...
Well, at trial, did the plaintiff ask the court to take judicial notice of that document to deem it admitted into evidence?
No. I believe Your Honor asked whether or not the substitution motion could constitute ratification, and it doesn't, and it can't. And the reason why is because Taylor, Bean, and Whitaker similarly cannot authorize Ocwen to act on behalf of a third-party entity, Freddie Mac. The only entity that can ratify the conduct of Ocwen in this case is Freddie Mac, and that wasn't done. Her testimony also, you don't review the records and get personal knowledge. Say, for instance, Appellee just argued, she reviewed the records, her testimony is sufficient, we don't need the document. Yes, you do. What if it had been the amounts due and owing? They can't prove the amounts due and owing through the testimony of a witness based solely upon a review of the records. They have to have the records in evidence. Israel versus State says this. You cannot testify as to the contents of a business record unless you admit them as evidence. This court, just months ago, followed that decision again in the Sauce versus Federal National Mortgage Association case. In Sauce, the witness testified from handwritten notes at trial that were based upon her review of the records. Again, this court said, you can't do that. You have to have the records. It's that simple.
Well, if we were to analogize to a situation where she was presenting a summary, you would have to have some advance demand or request by your client to have the actual business records there before the summary is used.
Yes, Judge. I believe it's 90.956 governs summaries, and you have to provide the opposing party with notice. You actually have to file a notice of using a summary with the trial court, which was not done, and you would also have to provide opposing counsel or opposing party with access to the underlying records.
And there's nothing akin to that happened here. I mean, these are not summaries, but no one made a demand to, let's make sure the actual records are here.
I don't view this as a summary issue.
Okay.
This is just a straight up hearsay problem.
All right.
She can't testify as to the contents of the servicing agreement that authorizes Ocwen to act without producing a servicing agreement. And the cases make clear, Elston, Kumar, and Wega make very clear that a real party in interest Ocwen can be a real party in interest. I do not argue with that proposition. But if it goes to trial, they have to prove that. And part of proving that is proving that that the principal or person above them ratified or authorized their conduct. That simply wasn't done in this case.
Tell me what I'm missing here. I'm looking at footnote 11 in Kumar, and I believe this was brought out by your opponent. And the note says, it's long been the rule in admiralty cases that an agent may sue on behalf of the principal as long as the agent's action is ratified. Because Florida's real party and interest rule is permissive, no joinder or ratification language is found in the rule.
I agree with that statement entirely, but that's as to stating a cause of action. I have absolutely no qualm agreeing with opposing counsel in the court that Ocwen could state a cause of action as a loan servicer.
Your focus is on proof at trial.
Proof at trial is the difference.
If your client admits that that's who he owes.
Well, I don't
mean-
I'm not necessarily clear that he was admitting that he owes Aquin. His bankruptcy petition
Well, that's what it
spoke as
says
to.
in the briefing. So if he doesn't, then somebody told us wrong, because that's what it says.
I do realize it says that in the briefing. I can tell you where in the transcript it would be. It would be under cross-examination by counsel at trial for plaintiff. But long story short, I'm not even sure that is an admission of
Before
Aquin's
you go-
ability.
You say it was like cross-examination by the plaintiff?
Yes.
Does that mean you called your client?
Yes.
Would that have been after the motion for judgment of involuntary dismissal?
My motion for judgment of involuntary dismissal was made after the conclusion of all evidence.
Okay.
So, yeah, we opened
I
up our
understand.
case and then at the end.
Okay.
So getting back to it, the notice of change of address is the last thing I want to touch on. And Appellate argues that it had to be in writing, and that's not what the mortgage says. The mortgage specifically says in paragraph 15, and I'm reading directly from it, if the lender specifies a procedure for reporting borrower's change of address, then borrower shall only report a change of address through that specified procedure. There are many instances in which loan servicers permit you or allow you or require you to do it online, phone, whatever. Just because he didn't send a writing doesn't mean that it was an invalid notice of change of address, especially if the notice of change of address was acknowledged. And we know that it was because Aquin's own records reflect that the mailing address was 2028 Shadow Pine Drive, and that's the third page of Exhibit 3. You'll see the top. It has property address, and then underneath that it says mailing address, 2028 Shadow Pine Drive. So if their own records show that they adopted that address, I don't see why the lack of a writing would be problematic, especially when the mortgage permits the lender to specify other procedures to report that change of address. And unless the court has any further conclusions, we ask that you all dismiss involuntarily. Thank you.
Thank you. Thank you both. That will conclude this morning's session. We are officially in recess. We're over, is the case, maybe. We don't.